we'll again be discussing with one small important topic, that is the revenue officers. We shall very quickly discuss with the procedures of revenue officers and their powers. See, when it comes to the revenue officers under the Land Revenue Act, a revenue officer is said to be considered with such person who is not below the rank of the Tahsildar. So till Tahsildar, all those officers are called to be as a revenue officers, and these revenue officers shall deem to have a power of exercising a jurisdiction on those of the revenue issues and decide upon those of revenue disputes. So in that way we can say they are also deemed to be considered as revenue courts for the purpose of this enactment. And when they are exercising with the powers that is been granted under the Act, they can also exercise the power, that is Deputy Commissioner, Assistant Commissioner, so also the Tahsildar shall have a power of exercising such powers, such rights of which the courts would exercise upon with. So the powers of revenue officers is that they can make an inquiry into the question. They can also order or decide with respect to the question arising for the determination of any right between the parties, like with respect to that of records, or with respect to the rights are concerned, with respect to the wrong entries in the records are concerned, or with respect to that of the boundaries and boundary marks are concerned, with respect to the area of concern. In all these matters, they have a power to decide upon with. And also with respect to that of the rights are concerned in respect of the land, he is also given a right on these authorities to exercise upon with. So where there is a dispute between the land, that is the parties, or with respect to that of other parties, or if the dispute is between that of the state government and that of the person, then in such cases, more particularly I say, with respect to the parties and entries in respect to those of parties are concerned, my friends, the right shall be exercised before the revenue courts. And mind this, see, what matter has to be taken before the revenue courts is that where any question of inquiry is to be decided with any such question arising out of the determination between the party and the state government is concerned, state or central government for that matter, state or state governments can also be the matter. If it is between the parties and the state government is concerned, then it shall be before the revenue courts. But if the dispute is between the party themselves, that is between one party to another party, then revenue courts are barred with the jurisdiction. That is, if one of each claiming a right over the property, as to the title over the property, as to the interest over the property, then revenue courts does not have a power to exercise and it is barred by its jurisdiction. So it should be always understood that while question of determining any dispute between the parties, the dispute should be with respect to the question of determination of right of one party with that of the state or government of any other person. So only then we shall see that this right can be exercised. That is, the revenue court shall have a power to exercise upon, to decide upon the disputes with respect of those proceedings which has been initiated. And in fact, section 25 says, gives out an inherent powers on these of the revenue courts, and says nothing shall deem to be a limit or otherwise affect the inherent powers of these revenue courts so as to make such orders which is necessary to end the justice. That is, to prevent the process of abuse of these revenue courts, the revenue courts shall also exercise all such power which is provided under the Act. So that's what we say. Section 25, my friends, when I am saying with this is somewhat more similar to section 151 of the Code of Civil Procedure, which speaks again, Code of Civil Procedure under section 151 speaks with the inherent powers of the code. The same section 25 for the revenue courts are concerned, it provides for the inherent powers of the code. That is, in order to have a justice delivery, or in order to provide out or in the hand of justice, that is, to prevent the any such act which would be an abuse on the process of the revenue courts, these revenue courts shall have a power to exercise the inherent powers of the court. That's what in Siddeshwara Yuvaka Mandali versus State of Karnataka 1981's decision. This is the High Court relying on various Supreme Court decisions. It said that the Deputy Commissioner cannot invoke the jurisdiction of Section 25, that is the powers under Section 25, to deal wrongly a claim filed before the Deputy Commissioner, where in fact that the same was ought to have been filed before the Assistant Commissioner. Because of the reason this, though we say that Deputy Commissioner by his rank is superior to that of the Assistant Commissioner, but when it comes to the jurisdiction of the court, the Deputy Commissioner cannot assume the power by exercising its inherent power in himself, and he can decide the matters of what the Assistant Commissioner has a power to do with. So I can say, my friends, it is something irregular exercise. It would become an irregular exercise of jurisdiction, what we understand in this scenario. So though some extent we shall say that it should not be made when it is wrongly filed and wrongly exercised, when it is wrongly filed without knowing to the parties, and even where the Deputy Commissioner was not aware with the exactness as the entertaining of matter should be done by him or not. In such cases, if it is been done, the order so passed by him, it would not become ineffective. But where the Deputy Commissioner comes to know, prima facie it is being made out that this is a case which should not be decided by him, but it should be decided by the Assistant Commissioner. But if he still exercises this right, such powers are not allowed to go, and that is not what we call it as inherent power. That is what the High Court, Karnataka High Court has came up saying this. That is in Siddeshwara Yuvaka Mandali, saying that though there is an inherent powers under Section 25 to the revenue courts, but this powers cannot be exercised arbitrarily. So this was one thing that we come across with this. And I was also saying you, it is very similar to that of the provision of Section 151 of CPC, that is 151 of CPC. The same was taken in case of Narasimhamurthy versus State of Karnataka. In this case, the Assistant Commissioner, while deciding the provisions or under the provisions of Karnataka SC/ST prohibition of transfer of certain lands, invoke the inherent powers of the court. And when he invoked this Assistant Commissioner, when he invoked the powers of this court, the High Court held that when the act and rules are being made, that is under the code, which is a complete code in itself to determine upon a particular matter, then the Assistant Commissioner cannot invoke any other provision or is not left open to invoke any such provision unless otherwise that is being provided under the code. See, it so happened in this case, this Assistant Commissioner exercised his inherent powers under Section 125 of the Land Revenue Act while deciding upon the code, that is of SC/ST prohibition of transfer of certain lands. So there the court looking into, the High Court considering into, when there is an exclusive code provided to the person, that is to the court, to decide upon the matter, then in such case, I cannot take, that is the Assistant Commissioner cannot take the benefit of the code that is provided under Section 25 and he can go decide upon the matter. So there again it says, that is the Assistant Commissioner has arbitrarily exercised his power invoking Section 25 of the Act as concerned, that is Land Revenue Act is concerned. So though there is a powers that is being provided under Section 25 of the Act, inherent powers are being provided, but still, my friends, we shall see that it cannot be hacked or it cannot be invoked arbitrarily at the whims of that of the authorities or the revenue courts are concerned. So in this way, my friends, Section 25 cannot be exercised in derogation with the specific provisions where there is a special enactment made to this. Or even for that matter, a Land Act is concerned. See, when I say Section 151 of CPC is there and Section 25 are both similar, I cannot invoke Section 151 while deciding upon the revenue issues are concerned. This is what we have to understand. So it speaks about as how the exercise of powers can be made. On the other hand, it also speaks upon with the place of holding the enquiries. See, with subject to such directions and controls and supervision or supervision that is being made, the revenue officer shall also cause an enquiry and make an hearing as to the case may be outside the local limits of the jurisdiction too. Sometimes it may becomes necessary that they may require to have a visit to the place itself, required to have a master of that place itself. So having conducting an inquiry, they can go also exercise this procedure of inquiry, or procedures of inquiry can be made even outside the local limits of the jurisdiction of that revenue courts, provided where such direction and control under the such direction and control it is required to be carried upon with. This is one such power that what the revenue courts could exercise upon in respect of the administration or in respect of justice system to that of the revenue disputes are concerned. Otherwise than this, we shall also see the powers of transfer of cases is being provided. That is, on the application before the tribunal by any of the party or on behalf of any of the party, if it is of the opinion of the tribunal that it is in the reason or on the reason of expedition of end of justice, the tribunal can pass an order as the case or to the classes of case arising out of such transfer, saying that this matter shall be transferred from one divisional to the other divisional commissioner. That is just to expedite the matter, or in the interest of justice, they can also be transferred from one divisional commissioner to the other divisional commissioner. So also, the divisional commissioner, if he is being made with an application, then he can also have a power of transfer of the same petition from one revenue to the other revenue officer too. That is, where the application is being made for the divisional commission for transferring upon, that is from one district to the another district or from one place to the another place, then he can also do the same. Likewise, the deputy commissioner can also transfer any cases for an inquiry and passing a decision, maybe on his own or on the application to any of his subordinates from him. So in all this manner, my friends, we can see that there can be a transfer of cases from one area or from one revenue code to the another revenue code. The deputy commissioner may also sometimes, if on the application made, can withdraw any case that is being filed before his subordinate on its own, and he can also deal with those cases for himself unless where he has a power to do it. That is, sometimes suo moto, if he comes to know that the powers are being exercised wrongly, he can make call for upon those cases, or on the application made, he can also call upon those cases and withdraw those cases from that of the subordinate courts or from the subordinates of him, and he can make his inquiry in that regard. So all this are being provided for the revenue courts as concerned. A part of this we also see, if you go to the internal powers, what is being exercised, the power of taking evidence, summoning, giving evidences and production of documents is also provided, which says every revenue officer not below the rank of Tahsildar, as we say, because these are the persons who are considered to be the rank of revenue courts, can exercise the powers of revenue courts. So not below the rank of Tahsildar or the assistant commissioner of their department, concerned department of land records or whatever it is on their department, shall have a power to take an evidences of such person on oath. So in that regard, they can summon up any person who in accordance with is necessarily required to come, answer before them, or produce such documents for the purpose of this inquiry, what is being called. So any person who is being summoned to, if it is the duty on him, is bound bound upon the person to attend such person, that is to attend such person to before the court or before an authorized agent, that is through him or by himself or through an authorized agent, he should come and make his appearances before the court. But where if a person so summoned, after having summoned, if he is not appearing before the court, or if he has not made his any representation to that of the agent, in order to give the evidence or the witnesses, then he shall also be compelled to appear before the authorities, that is before the revenue courts or before such authorities. So every person is required, when summoned, is required to appear himself for the examination and give out his evidence or make his witnesses, and is bound to state all those true statement in respect of those admission, and also produce those documents which is in position and what is required for the necessary adjudication. So it is the duty of that person when it is called upon. As I said under section 32, there can be also a compelling of attendance of witnesses and examination of witnesses. As I was mentioning to you this, my friends, after having a summons made to the person, calling upon him to make his appearances before the person, that is before the authority, whether it is DC or AC or Tahsildar, if a person fails to make his appearances or fails to produce that documents or fails to comply with that of the services of summons what is being made to him, then every such officer may also issue a bailable warrant against him, that is arrest a person and to produce him before, or he may also has to order for furnishing out such security for his appearances on his appearance before them, or they may also impose a fine for his non-appearances for having given with the opportunity to make his appearance. So all this can be exercised by that person, but however we see that we see that such person can also be exempted from making his personal appearances only under exceptional cases where he is unable to appear before because of his sickness or because of his infirmity what has been caused to him. So in such cases he is being allowed or exempted from that of making his personal appearances. And under section 38, when a person makes his appearances, there are two types of inquiry which could be called. One is formal inquiry and another one is summary inquiry. We can go with these two types of inquiries that could be made, or inquiry into a person. When I say formal inquiry, section 33 lays down the procedure to be followed in respect of formal inquiry, and section 34 provides for going with the summary inquiry, section 33 and 34, which says that is when you are going for a formal inquiry, it should be determined on the question of what an inquiry is going to be conducted. I can say in this way, my friends, that is when you are making an inquiry, it should be in a prescribed form, and that is for the purpose of determining the question, which shall be made both in English or it could be in the local language, in any local language of which they know. You have to frame out a question, you have to make out those questions. Maybe I don't say it should be made in writing and it should be given to him. It is not that. That is, you should be determined that what you want to make an inquiry, on what issues you have to make an inquiry. So on those issues, my friends, you can make it either in English or in the local language. This is the first one. The second one is that it says that the officer who is conducting an inquiry is required to take an evidence himself due, that is whatever that evidence he should be taking in writing, or where if there is a due to the physical disability or for any other cause, if such evidences cannot be taken in presence, then he shall make a personal hearing under the superintendence and direction of such other person, and the same shall be recorded and it shall be signed by such person who is giving his inquiry report. I repeat this. See, many a times it may so I may be an illiterate, I may not be understanding, so I may take an help of another person. Or if I am giving certain thing, now everything is been made in writing, you have to make your written submission before the authorities also. But when it is going on inquiry, when an evidence is being taken out, a due personal hearing has to be given, and under the superintendence of and directions of any such person, an inquiry has to be conducted and it should be signed by the person who is doing this. This is one way you have to do. And every such decision made by the order of a formal inquiry shall have a complete details on the grounds on which it has been made in writing. You have to make it in writing and it has to be given with. So this is how formal inquiry can be conducted. Under section 34, my friends, we shall see that the officer who is conducting an inquiry shall also go in the form of the summary inquiry. Of course, the concerned revenue court shall have a power to decide in the mode in which it has to be carried with. If they have for formal inquiry can be conducted, or summary inquiry can also be conducted in. I'm not speaking inquiry. So the officer who is conducting an inquiry shall himself record in his own hand. That is how it go. It shall himself record in his own hand. It shall contain all those evidences and minutes of the proceedings of which the inquiry is being conducted. The material averments has to be made to that of the parties, and the decision of the reason for the same should also be specified by such an officer. That is, where the formal and summary inquiry, when it is being conducted, it shall be conducted to be as a deemed, or it is deemed to be caused as a judicial proceedings which is being initiated. The inquiry is said to be called as judicial proceedings. And in this regard, my friends, they can also make any other inquiries apart of the formal and the summary inquiry when necessary. And they can also enter into any such land premises for the purpose of measurement, fixing, inspection of boundaries. And in all such cases, my friends, it is necessary that, my friends, we shall see that any person, if they required, they can also evict any such person where the person is said to have been in the wrongful position. So all these are the functions of the revenue courts. I'm speaking revenue courts who could function upon in all these areas. So as soon as the question is asked that what are the procedures and powers and functions are the procedures of revenue courts, first you have to establish what is a revenue court and how revenue courts are function or how it is being made. So in exercising their power, they also have an inherent power. So exercising their inherent power, they can do all those functions, and provided of this, they can hear the claims, petitions made before them, and they also have a power of transferring the cases. They also have a power of taking the evidences, summoning up of the persons, or summoning up of the person for producing out of an documents, and also they can compel upon such person to make his attendance, which all this can be carried either in the form of formal inquiry or summary inquiry. And in this process, my friends, they have an inquiry to conduct at whether formal or not is left to them, and they can also enter into, that is, the physical inquiry can also be conducted. They can enter into the land, take out the measurements, take out the fixation of land, inspect the boundaries that is been there, and if they come to know that there is some wrongful person made out, they can also evict the person. So these are the things which you have to answer when the question is asked with the powers of the revenue courts. Who are the revenue courts? That's why we said the deputy commissioner, assistant commissioner, then the tahsildar, are these three bodies which we can consider. And above this, it is High Court, my friends. We shall say High Court is common, which is an appellate court we see. But these three courts are said to be called as the revenue courts for the purpose and the act is concerned. So this is how you have to answer when this question is asked for you to write the examination, my friends. Friends, this is with the thing. Next comes, when I'm discussing to you with, I'll be discussing to you with the constitution and powers of the revenue appellate tribunal. Friends, when it comes to that of the special bodies which is being constituted for the purpose of trying and disposing of the matters relating to that of the revenue issues are concerned, I can say you this is the superior body in respect of the revenue courts are concerned. But of course, even against the orders of the tribunal, appellate tribunal, you do also have a power of having preferring to that of the High Court. But when it comes specifically with that of the revenue courts as concerned, we have tahsildar who would have a right of correcting of all those kata changes or records, entry of records and other things. And we also see there is a first appellate tribunal is the assistant commissioner of the revenue department or revenue courts which we call it as, and the third one is the Deputy Commissioner. So these are the three major organs, and above this we have the Revenue Appellate Tribunal. And how is this Appellate Tribunal was brought into? How it was formed with? Friends, when it comes to the Appellate Tribunal, today we see that the Karnataka Appellate Tribunal was established under the Karnataka Appellate Tribunals Act 1976. So this is the piece of enactment which gave out a way for the establishment of trying out the matters of revenue issues are concerned, and in fact it is this body is given with a power to hear against all those orders of a competent authority under the Karnataka Land Revenue Act 1964. It is also given with the power with the allied laws, something like the Karnataka Cooperative Societies Act 1959, Karnataka Sales Act 1957, Karnataka Entertainment Tax Act 1958, and also, my friends, Karnataka Entry Tax Act also. So with respect to all these issues are concerned, the Karnataka Appellate Tribunal has been empowered with. But for us too, we see that what is more concerned is how is this appellate body trying out and disposing the matter in respect of the Karnataka land revenue issues are concerned. We said this, we understood just now like this. This is a common body or common appellate authority for trying out all those issues relating to the revenue department, cooperative department, and also commercial department. Though it is a common body, but from the point of our syllabus, we are only required to go with how this body would exercise its power, do its function in respect of deciding the issues with respect to the revenue issues are concerned, or with respect to any litigations that are being made out with the revenue department. In fact, my friends, a very common question, maybe with a different form of framing the questions can also be made, but very common question which we come across, and an important question which we can come across with this area is they would be asking you in like this, saying that explain the procedures to be followed by the revenue courts in deciding the dispute between the parties. Or they may also go with the question asking to you with explain the composition, functions of powers and functions of the Revenue Appellate Tribunal. More specifically on this, they may straight away, one is with the procedure they can go, or they may also go with the composition and functions of the Revenue Appellate Tribunal. So in the light of these two questions what I have just mentioned to you, I'll be discussing my area here, my friends, from the point of your examination. Sorry. Now, as I just mentioned, this is an enactment, or it is a piece of, or it is such a body, autonomous body I can say, which has been formed under the Karnataka Act 19, that is Karnataka Appellate Tribunals Act 1976, to hear out all those appeals from the competent authority of all the common areas, that is Revenue Department, the Cooperative Society Department, and also Commercial Department. And in fact, if you look out with the composition of this Appellate Tribunal, it says that the chairman plus 8 persons, or 8 benches I can say, chairman plus 8 benches can be formed together. 8 benches, and of course the chairman has a power to specify that where the bench shall have a sitting, that I will be discussing to you later. And who is this chairman? In fact, the chairman shall be a person who is a senior IAS officer, and it shall not be below the rank of divisional commissioner. And a person who is qualified to this extent can be appointed as a chairman, or can be designated as a chairman of this Revenue Appellate Tribunal. And these chairmen shall have a power to constitute the benches. And each bench of which it is being constituted, especially to try out the matters of revenue issues are concerned, I am speaking with, there shall be one judicial member and one administrative member. And when it comes to the judicial member, this judicial member shall not be below the rank of district judge. So, such person shall be appointed for the bench who could try and dispose of the matter. In fact, the chairman shall also have a power to constitute the full bench, which would be of not less than 3 in number. That is, including chairman can also become one of the member of this bench. So in such a way, my friends, we shall see that the composition of the appellate tribunal can be constituted, and in fact this is the only one body, or I can say a single appellate tribunal for the entire state of Karnataka. So this is one such body we can say, which would hear the matter of any such appeals which is being made from the AC or DC, and it can try and dispose of the matter which has been brought before the appellate tribunal. In fact, that is section 3, which has spoken to with the composition of this number of persons, and the section 4 of the Karnataka Appellate Tribunal Act 1976 speaks with where the principal office or principal seat of this tribunal has to be constituted. I'll be just excluding those sections when I'm going discussing to you with, but I'll be just going on with what it is. So, by virtue of this provision, it says that the principal office of the tribunal or principal seat of the tribunal shall be placed at Bangalore, because as Bangalore is the head of the city, like which we see, that is capital to that of the Karnataka. So it is been placed in Bangalore, and the chairman shall have a power, as I then said, that he can have as many number of branches of this tribunal which is satisfies from time to time, subject to the conditions what has been imposed or prescribed by him, saying that where the sitting shall be made in, that is in the places other than that of Bangalore. So on the powers that is being given by the chairman in this regard, or on the decision taken by the chairman in this regard, there shall also be a sitting of this appellate tribunal in such other places as the state government make by its notification. In fact, it would be recommended by this chairman, and thereafter the state government shall make a notification for the same, that where the body, appellate body, or the benches of this body would be situated with. So in that way, my friends, but however we see that the principal office or principal seat of all this tribunal shall be there at Bangalore. And this tribunal has a power, that is, it shall has a power to function upon or to exercise upon all those functions which is been given to the tribunal by the state government. That is, whatever the powers that is been assigned or authorized by the government or by the authority or the officers of the government for time being in course, or for the time and again, whatever the state government gives out an authority for this person, that is this appellate authority, in such powers what is been conferred upon to them, they can exercise all such powers provided to them. So in this way, the powers are also exercised. And what are the powers that they can exercise? That is, generally we say under section 5, saying that all those powers can be exercised as that is been notified by the state government. But in specific, if you go, what are the powers, what are the functions that it does with? See, the basic function that the tribunal would do in conducting its business or carrying upon its business is that it is with respect to the admission of appeals and revision. Whenever an appeal is being preferred before this appellate tribunal, the power is there on the part of this tribunal to admit those cases or even dismiss those cases or those appeal where the claim is not being made out before the tribunal. So the powers is there on the part of this appellate tribunal, that is KAT, for admitting the petition or appeal when it is being filed before the tribunal, or even it can go exercise the power of revision. This is one. The second power is also this, we can say, it shall also have a power of admission of those appeals or revision even where the appeals or revision is being made on the expiry period, or even after the expiry day, for having preferring an appeal or revision is preferred. How? If the same is not being preferred but preferred on the later day, then such can also be admitted, or the revision can also be admitted, where if the appellate tribunal is satisfied to this effect. In the course of having hearing this admission and the revisional issues are concerned, the appellate tribunal do also have a power to pass any such orders of stay in the appeal, or where on a reference is being made out before the court. So all these are the power, and of course we have one more other power which could be exercised, is that is, it can also decide upon the matter of interlocutory issues are concerned, or interlocutory characters are concerned. So with these powers, or in such way, or to this extent, we shall see that the tribunal shall have a power of exercising upon any dispute which is being brought before the tribunal. And again it says, that is under section 7 of the KAT Act, it says that withstanding to the provisions contained under section 4 of this act, the chairman shall have a power to constitute the benches. That is, he shall fix what shall be the number. Generally we say that two persons would constitute the bench and they would be hearing upon the matter. One is, as I then said, it is the person who is not below the rank of district judge, or who shall be qualified to be acting as a district judge, shall be the judicial member, and one administrative member shall be appointed for the purpose of the same. So this would be a bench, but where it is also the powers on the part of a chairman should decide that is to decide that what shall constitute a full bench, what shall be the number of members, and when the matter should be referred to that of the bench, this shall be decided by that of the chairman. And when it is a full bench that is being constituted, that is, which is not less than 3 members, then in such case, if a matter has been referred to that of the full bench, then the decision so taken up in the bench would be on the basis of majority. So in such a way, we shall say that the adjudication of any disputes which is being made before the member or before the tribunal shall be heard upon with. And also we see there is also a powers on the part of the tribunal, that is, the tribunal can either on its own motion or on the application of the parties who is being affected by this, that is affected by the order, shall have a power of reviewing the order passed by its own, or wherever where the tribunal deems necessary that there shall be a review of any such order that which it has been passed out with, then the tribunal shall go proceed for having even reviewing its own order of which it has been passed, provided it says that is, the tribunal should be satisfied to the extent that there has some discovery that is being made out in respect of the adjudication which the court has, that is, which the tribunal has made with. It has to come out, that is, the party should come out of certain discovery which new things has been brought in, or new and important things has been brought in respect of the claim which was not knowing before to them. In such cases, that is, the tribunal shall have a power to review, provided, again I say, provided that this piece of discovery or this piece of evidence was not known to the person even after the due diligence, or it was not to the knowledge of the person when the claim was being made or when the appeal was being preferred before the tribunal, and it was a sheer or mere mistake which has been caused by them, which at the time of filing the appeal before the appellate tribunal. And it also says that if the tribunal can also, not only on the application, even where on its own motion, if it is satisfied to the effect that is, there is some error made out latent or apparent on the face of it, or prima facie if it is being made on that of the adjudication that what the appellate body has given to with, in such cases the tribunal shall also have a power on its own, that is, on its own motion, suo motu we call it as, suo motu, the tribunal shall take upon such matter for the subject of review. So in such a way, my friends, we shall see that the powers could be exercised by the tribunal. And new insertion has been brought into this section, that is section 8A. During the course of this revision, if the tribunal has been satisfied with, or where the tribunal has failed to decide upon some erroneous issue that is being made out before the court, that is before the tribunal, or where in such an adjudication, if any question of law is said to be involved in, then the tribunal shall have a power to make the matter of reference, that is this part can be referred to the High Court, and High Court shall also have a power in deciding upon. Or where it is erroneous decision is being made out, or where erroneously we can see that the prima facie some mistake is being committed by the tribunal, appellate tribunal, in such cases too, the High Court shall have a power under section 8 capital A to entertain the matter by way of revision in respect of such erroneous decision that is being given to. But otherwise than this, we see that once when the tribunal, when a petition is being made, appeal is being made before the tribunal, on such appeal, if the appellate body decides upon the matter which is in question of dispute before the appellate tribunal, then that orders what is being passed shall be a finality in itself. It becomes a final order. It shall not be questioned in any court of law after the appellate body has given out its adjudication in respect of the same. So this is one another powers that what we can see, that the tribunal shall have a power to hear and exercise upon the matter. And likewise we also see there is a power on the part of this tribunal to call for returns, etc. That is, the tribunal may subject to such an appeal that is being filed before it, or revisional powers are being exercised before the tribunal. The tribunal shall also have a power to exercise such powers calling upon such returns which is there. That is, when a petition or when an appeal or revision is being made before the tribunal shall have a power to call for records, to call for such authorities subject to the jurisdiction of itself. It can call off returns from all those, from call authorities to give back or surrender of all those necessary requirements before the tribunal. And in this regard, it can also issue a general direction in a prescribed form for regulating the practices of giving out the records to that of the tribunal. So it can call for the returns, or it can call for the records, or it can call for the documents. It can call for the petition which is being made before the lower court, that is lower judicial body. I don't mean to say lower court of civil cases are concerned. I am speaking with the revenue courts. Lower courts of the revenue issues are concerned. It can call for those of the records what it is being made. So the call of returns can also be exercised by that of this appellate body. And in the proceeding of this, my friends, anything that is being carried in this, that is, any process which is being carried in this regard shall be considered to be as a judicial proceedings. Or I can say you in this way, that is, all those proceedings which are initiated by the tribunal, that is appellate tribunal, is considered to be as a judicial body within the meaning of section 193 and 228. So you can say that is, you cannot just say it is a quasi-judicial body. No, it is a judicial body which it is having with. And under section 11A of the Act, it says that this being a judicial body in itself, because we consider that to be as a judicial body, the tribunal, while exercising its power, it can also exercise all those powers of what the civil court would exercise with, like summoning of the person, summoning of any authority, summoning of witnesses, or it could be for, that is, on the reason of requiring of any discovery. It can call for production of any document, or it can also call for an examination of any person on oath, or requesting of any person, or there could be a requisition of any public records to be filed before the tribunal, or copy of such can be called from time to time from the tribunal to be submitted before the tribunal. It can also call for the production of the evidences. It can issue commission for the examination of parties, etc., etc., etc. We say that all those powers which are exercised by the civil courts are concerned, all those powers can also be exercised by this appellate authority. And otherwise than this, my friends, we shall see that the tribunal shall have a power of hearing the regulation, not hearing the regulation, making the regulation in respect. That is, the tribunal shall, with the previous sanction of the state government, it shall have a power to make such regulation, make such rules thereunder for the practices of the procedure in the tribunal. So there are several powers when we go on with. Of course, when you come down to section 16 of the KAT Act, it also empowers upon the tribunal to have a transfer of pending proceedings. That is, from the day of which the commencement of this act of KAT has come into force, and there is a seizure of all those functions which was there before the appropriate authority, that is before the proper authority. That is, it says that whatever the matters that was been pending in the other courts with respect to revenue issues are concerned, after the establishment of this tribunal, the tribunal shall have a power on the days it is being formed with. It shall call upon all those matters to be transferred, and all such matters relating to that of the issue of revenue concern shall stand to be transferred to that of the tribunal. So what we can see here, this, my friends, when you just go into the powers of appellate tribunal, you can say that power to hear, that is on the basis of appeal or revision. Revision, we see it has a power to hear the appeal and revision, and this appeal and revision can be even heard where it is an expiry has been cast, and it can also have a power of reference to the High Court, that is it's on motion, or it can go for a revision of the same, and it shall also have a power of exercising all those powers of the civil court, can exercise all those functionaries of the civil court, make regulation in this regard, and also it has a power of transferring the cases from that of its constitution. So all these are the powers what can be exercised by that of the tribunal. And apart of this, my friends, apart of these powers and functions what it carries upon, but we shall see that there is certain other powers which are also exercised under the Karnataka Land Revenue Act. And of course, what I was saying you here is also there under the Karnataka Land Revenue Act. I am not just speaking with the Karnataka Appellate Tribunal. Even it is under this, my friends, we shall see that there is a provision which has been made under the Karnataka Land Revenue Act, that is from section 40 to 48 of the Karnataka Land Revenue Act, speaks with these powers and functions of the Revenue Appellate Tribunal. So in this, that is by virtue of this Karnataka Appellate Tribunals Act and also Karnataka Land Revenue Act, we see that the powers are being exercised by the tribunal. So what are the other powers that the tribunal shall have with? The chairman, as I then said, the chairman is the superior head of this, especially of the tribunal. He shall also have such other powers, that is, he has a power, as I also saying about them, that is to constitute the number of benches, and he shall decide that who shall be the members among those benches, including himself, he can be, as I was saying to you, and he shall also have a power of distribution of work, transfers of appeal from one jurisdiction, that is from one bench to that of the another bench, and he shall also have a power to convene the meeting of their members of the tribunal for considering any important question or the question which is connected to the functions and working of the tribunal. So he has all this power, that is, he can say what shall be the number of bench, where the benches has to be constituted, who shall be the members of this, and also to call upon a meeting to discuss upon the tribunal issues are concerned. All these are the powers which the chairman himself would exercise in respect of having doing all this work. And this is one. See, generally when I say you with this, see, the tribunal is said to be considered as a bench. That is usually we shall see that one judicial member and one administrative member would be appointed in this regard, who would be hearing upon the cases in respect of any litigation which is being made. However, friends, we shall also see there can be a single bench which could be constituted by the authority of the chairman. And it says that withstanding to the provisions of the act, the single member of the tribunal also can exercise such powers of the tribunal. Like the single member can exercise like admission of any appeals or revision petition which is being made before the tribunal, or admission of appeal or revision after the time of expiry, pass a stay orders pending disposal of any appeal or revision or reference or other proceedings, or even he can also discharge his function if the interlocutory characters are concerned, that is in respect of those of appeal, revision, reference or other proceedings. He has this. So the powers can be delegated. The chairman can delegate this power to the single person of the tribunal for in the cases of admission, in the cases of giving any stay orders, or even to pass any such orders which is of an interlocutory order. So in this kind of natures, he can exercise the powers, provided it says that any person aggrieved by the rejection of this appeal or by the revision of what the court was asked to make with, or the petition may, that is if the petitioner who has been rejected with this of appeal or revision, then he may go apply for revision or for such other orders as heard and disposed by the bench of members. That is, if the same is rejected by the single bench judge, then he can go by way of an appeal or for revision before the bench which has been constituted, and the bench of not less than 2 in number shall have a power to hear upon, and on such appeal or such application has been made, they shall be heard and disposed of by this bench of not less than 2 in number. So this bench can decide upon with respect to such matters where when the admission or stay or interlocutory order sought is been rejected by them, and where appeal or revision or reference is heard by the bench consisting of 2 or more members, then it would again be decided, that is if there are more than 2 in number, then that would be decided at the option of majority. So in such way, my friends, we shall see that the powers of these tribunals are exercised by this tribunal. And more particularly, if you look how the powers are being exercised, I would like to go with one power which the tribunal would exercise is the power of review by the appellate tribunal. Of course, as in cases of appeal that is being filed before the tribunal shall have a power to decide upon with all those issues on which the appeal is being preferred. Likewise, we shall also say there is a power of review on the part of this tribunal. Section 44 of the Land Revenue Act speaks upon with this, provides for this. And how is this review powers are being exercised by the tribunal? See, the tribunal may either on its own motion or on the application made either by any of the one of the party to this effect shall have a power of review or pass such an order by itself or pass such any orders as it thinks fit. It can pass in any manner. That is, whatever the tribunals is satisfied to the extent of this, it is satisfied that it would go in this way, then the tribunal can pass an order of in such review what is being made before. But one thing we should see here is no such application shall be entertained by the tribunal unless where the tribunal is satisfied that there had been some discovery of new and important matter of evidence before them. It cannot just, see, exercising this power under section 25 of the Act, that is inherent powers of the tribunal or any other authority I am speaking with, the powers cannot be exercised at the whims of the tribunal. It is not. Though sometimes it is exercising on its own motion, but that cannot be exercised immediately. it says that whenever when the tribunal is exercising this power, when we say though as it thinks fit, the thinking fit is not arbitrarily exercised there too again. That is, the power of review of its own order can only be exercised where if the tribunal is satisfied that there has been made a discovery of new and important piece of evidence which would be a vital or which would be materially required for the purpose of deciding upon the matter. If it is only a secondary piece of evidence, it is not a primary piece of evidence, it is a secondary source or secondary piece of evidence which would only prove if the circumstantial issues are concerned, then they need not be taken into. That's why we say that when any new important piece of evidence is being made out before the court, which would negativate the jurisdiction or which would negativate the adjudication, not the jurisdiction, adjudication of the court is concerned, then in such case the court can proceed, that is tribunal can proceed with the due diligence. And after this, the court, that is the tribunal, when I say court, tribunal, the tribunal shall exercise its adjudication with a due diligence, and that was to see that the same was not within the knowledge at the time of the party presenting the petition or presenting the appeal, and there is some mistake has been made out by the person which is not a willful or negligent in nature, and if the such mistake is also been known or made out error on the apparent on the face of record, and if it is been found sufficient with this, then the appellate body shall have a power of review. And here the two restrictions are also imposed against this tribunal. That is, no order shall be passed by the tribunal, or no order shall be varied with respect to the order of what the tribunal has passed, unless a notice is being made to that of the parties. This is the first condition. The second condition is that where any orders affecting to the person, that is to the person who is in question, that is a private person in question, shall not be reversed unless where except an application is being made by the affected party. So subject to these two conditions, I again repeat the second one, sorry. No order shall be passed affecting the question of a private person that is shall be revised or reviewed except that is the affected party has made an application in this regard. Unless an application is being made by this affected party, no other person can make an application. But otherwise than this, subject to these two conditions, my friends, we shall see that the grounds of review can be taken either suo moto or on the application made by the party. The powers is there on the part of a tribunal to entertain upon the matter. And that is, it says, when I go for the question of review is concerned, probably I have not written here, review reference, sorry. Review, unless I go for review here, the review shall be made or application for review shall be made within 90 days from that of the day of its order. So within that day, if you come across with any latent defect or patent defect on it, you can make an application before the tribunal for reviewing. That is, you can make a review petition before the tribunal for the purpose of the same. And even in this application, when you are filing this application, section 4, section 5 and section 12 of the Indian Limitation Act is equally applicable. That is, which speaks with the sufficient cause also. That is where the time spent bona fidely in getting the copy of the same. All these things comes there. So it says this, that is, in such cases, the Limitation Act is also applicable, and subject to this limitation, the review can be allowed by the tribunal. And the order so passed by the tribunal, when in respect of this, shall stands to be final, and the same cannot be questioned in any court of law. This is what it says. And in this regard, my friends, the same power as I was saying to you then, that is call of returns or call for returns, that is under section 46, the tribunal may also call for the returns or give out a direction in the prescribed form for calling the returns from that of any other person. and the proceedings what is been initiated by this tribunal shall be or should be considered to be as, or I can say deemed to be considered as a judicial proceedings under section 47 of the Land Revenue Act. And the tribunal, that is with the previous sanction of the state government, can also make a regulation or which are such rules or regulation which is inconsistent with the provisions of the act. That is such rules what is being made shall be to meet the end of justice. So in this way, my friends, we shall see that the composition and functions and powers of the tribunal can be exercised upon by the Revenue Appellate Tribunal.